Approval of the Senate calendar pursuant to Standing Order 32.4. The Senate resolves to extend the recess as to resume regular sittings of Part 4 of the fourth session on Tuesday, 23rd September 2025, and that the Senate calendar regular sessions of the fourth session 2025 be altered accordingly. Now, the floor is open for debate. With your concurrence, honorable senators, I may proceed to put the question. Very well. I will now proceed to put the question. The notwithstanding the resolution of the Senate made on the 19th of February 2025, approval of the Senate calendar pursuant to Standing Order 32.4, the Senate resolves to extend the recess so as to resume regular sitting for Part 5 of the fourth session on Tuesday, 23rd September 2025, and that the Senate calendar regular sessions for the fourth session 2025 be altered accordingly. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Next order.
Order number 9, motion, establishment of a special committee to investigate the proposed removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County.
The majority leader.
Mr. Speaker, I rise to move the following motion, which is the establishment of a special committee to investigate the proposed removal from office by impeachment of Honorable Eric Mutahi, the Governor of Kericho County, that whereas pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act, on Friday, the 15th of August 2025, the County Assembly of Kericho approved a motion for the removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County. And further, whereas by letter reference KCEA/SP/3 volume 139 dated the Friday of 15th August 2025, received in the office of the Speaker of the Senate on the Monday, the 18th of August 2025, the Speaker of the County Assembly of Kericho informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly. And whereas pursuant to Standing Order number 33.3b of the County Governments Act and Standing Order number 81b1 of the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. Now, therefore, pursuant to Section 33.3b of the County Governments Act and Standing Order number 81b1, the Senate resolves to proceed on this matter by way of establishment of a special committee to investigate the proposed removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County. Mr. Speaker, this is another procedure that members are now accustomed to, that every time we have an impeachment hearing, the House must make a decision whether to investigate by way of special select committee or by the plenary the matter that is before us. Mr. Speaker, I can already hear what people are saying, much as I'm not supposed to, including my good friend Senator Boni Alwale, who's asking me that in compliance with the conflicts of interest bill that is now a law to declare my interest in this matter. Mr. Speaker, I have no peculiar interest in this matter other than justice for the people of Kericho. Nothing else. Mr. Speaker, that is not a subject of debate at this point. And the majority whip, Mr. Speaker, should know that at this point, what we are discussing is whether to investigate this matter by way of committee or by plenary, Mr. Speaker. And we have pursued both ways in the past with almost near equal results. If you look at the statistics, if I'm not wrong, Mr. Speaker, this must be the 17th or 18th impeachment that you are considering. And almost all, Mr. Speaker, have been considered almost in equal number, some by way of special committee, and nearly an equal number also, Mr. Speaker, by plenary. And both routes have returned the two possible verdicts, which is either to confirm the charges, Mr. Speaker, or fail to confirm the charges in equal measure as well, Mr. Speaker. The point, Mr. Speaker, is that there is no process or route, Mr. Speaker, that is flawed. It is the members to determine which route they want to consider a particular matter. Therefore, Mr. Speaker, reading the mood of the House, because I've been in this House long enough, and I know when people are listening, and I know when they are not, Mr. Speaker. Mr. Speaker, I beg to move and request the leader of minority, Senator Justice Retired Stewart Mazayo, to second this motion. I thank you, Mr. Speaker.
Asante Mstahiki Spika. Mimi nakataa.
Order, order, honorable senators. Order. Order. Senator Faki, you can only raise a point of order when a colleague is on their feet. Yes, what's your clarification that you're seeking?
Honorable Speaker, thank you very much for this opportunity. The leader of the majority party has moved the motion, and the minority leader has objected, negated, or objected to the motion. So in our standing orders, can we really improve that maybe there is a recourse? Because maybe I'm not satisfied with his recusal or refusal to second. So in our standing orders, I'm not talking to the speakers, to the senators. I'm addressing my time to the speaker, who is the end of this House. And if I was to talk to you not in this forum, I could have talked to you in other companies. So, Honorable Speaker, is it possible that at some point, maybe we can change our standing orders also, maybe in a way that if the seconder is not ready to second the motion, so the motion die there, or maybe we can initiate another motion another day, that those who are ready to support the motion, Honorable Speaker, can be able to do it. It has happened several times, Honorable Speaker.
Order, Honorable Senator. Conclude, Honorable Senator Fomeru. Kindly conclude your intervention.
So, Honorable Speaker, is it possible that we can have another option? Can we have another option that also this motion can still be looked at in a different way, Mr. Speaker?
Order, honorable senators, order. Senator Fomeru, you have valid concerns, but those concerns are for the future. We have a situation to handle today. The majority leader had somebody to second his motion. The proposed person was the minority leader who did not second the motion. The majority leader did not appoint any other person. It is his motion. So allow me to read the ruling on the effect of lack of secondment of a motion as per our standing orders. Thank you. Now, honorable senators, as you may have noticed, the Senate Majority Leader moved the motion at order number 9 on today's order paper. for the establishment of a special committee to investigate the proposed removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County. The motion failed to be seconded and therefore deemed to have been withdrawn pursuant to Standing Order 71 of the Senate Standing Orders. Now, Honorable Senators, as I communicated earlier by way of message, on the resolution of the Kericho County Assembly made on the 15th of August 2025 for the removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County, Section 33(3)A of the County Governments Act and Standing Order 81B of the Senate provide that the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. The motion having been withdrawn, the route of a special committee is abandoned. The Senate will proceed to investigate the proposed removal from office by impeachment of Honorable Eric Mutahi, Governor of Kericho County, in plenary pursuant to Section 33A of the County Governments Act and Standing Order 81B2. Now, Honorable Senators, at its meeting held today, Wednesday, the 20th of August, 2025, the Senate Business Committee considered the provisional dates for this investigation in the event that the matter was to be investigated in plenary. In line with the schedule of activities for an impeachment hearing in plenary, I hereby give the following directions. A, the clerk to issue invitation to appear to the parties on Thursday, 21st of August, 2025. B, the parties to file their responses with the Office of the Clerk of the Senate by Monday, 25th of August, 2025 by 5 p.m. C, the clerk to circulate documents received from the parties, including the plenary hearing program, to all honorable senators by close of business on Tuesday, 26th of August, 2025. And lastly, the Senate shall then investigate the matter in plenary on Wednesday, 27th of August, 2025, Thursday, 28th of August, 2025, and Friday, 29th of August, 2025. The Senate is hereby accordingly guided. Thank you. Let me read. Now, Honorable Senators, I have a further communication to make. I would like to acknowledge the presence in the Speaker's Gallery this afternoon of Ms. Carol Ann Nicolen Esterhusen, a Director of Legal Services from the National Assembly of the Republic of Namibia, and Andrew Kiprop Kaimugul, a student from the Moi High School, Kabarak. They are in the Senate for benchmarking and study visit, respectively. Now, Honorable Senators, in our usual tradition of receiving and welcoming visitors to Parliament, I extend a warm welcome to them, and on behalf of the Senate and on my own behalf, wish them a fruitful visit. I will call upon Senator Boni to extend a word of welcome, and also Senator Eddie Okech to do likewise.
Mr. Speaker, thank you for the honor. We all know the great history of Namibia and the people of Namibia. It is therefore my pleasure, Mr. Speaker, to welcome the young lady, and I hope that she's going to be able to meet her expectations here in Kenya. Welcome, and thank you, Mr. Speaker.
Mr. Speaker, I want to thank you for giving me this opportunity to also welcome the delegate from Namibia. I had the chance to visit that country when I was studying in South Africa in my high school days at the African Leadership Academy. Therefore, we welcome you to Kenya, and I hope that you learn the best from this upper house, and even generally from our parliament. and to the students from Moi Kabarak as well. This is the house that deals with a lot of issues with regard to money and resources that come to our counties, and everything to do with devolution. There's a lot to learn from this house, and therefore we also welcome you to learn as much as you can from Parliament, and I thank you, Mr. Speaker, for that opportunity. I hope they'll have a good time in Senate.
Now, honorable senators, I have another communication to make. Now, honorable senators, the leadership of the Senate across the political divide met today, this morning, Wednesday, the 20th of August, 2025. And during that meeting, the leadership noted with grave concern the allegations of bribery and extortion made against the institution of Parliament in general and the Senate in particular. The leadership of the Senate has also noted that the allegations have not included material particulars, including the specific individual senators against whom the allegations of bribery are made. Senators are called to a very high office of responsibility and accountability, and are required under the Constitution to live up to a very high standard of integrity and accountability. This is the thrust of a number of provisions of the Constitution, including Articles 1, Sub-Article 3, and Articles 10, as well as Chapter 6 of the Leadership and Integrity of State Officers. Senators take and subscribe to an oath of office to obey, respect, uphold, preserve, protect, and defend the Constitution. It follows, therefore, that allegations of bribery and extortion made against senators merit the most urgent and deliberate action and intervention. Honorable senators, to fight corruption requires a systematic and integrated approach in which all organs of the government collaborate and cooperate to the extent of their respective spheres. To this end, while there exist constitutional and statutory agencies for preventing, detecting, and prosecuting corrupt acts, and while the judiciary adjudicates on such matters, the legislature too has robust mechanisms for addressing the vice. Now, honorable senators, as you are aware, the Parliamentary Powers and Privileges Act, Cap 6 of the laws of Kenya, has an elaborate framework for Parliament to deal with errant legislators. Section 15, subsection 5 of this Act mandates the Committee of Powers and Privileges, which is chaired by the Speaker, either of its own motion or as a result of a complaint made by any person, to inquire into the conduct of a member whose conduct is alleged to constitute breach of privilege in terms of Section 16 within 14 days of receipt of that particular complaint, and to make recommendations to the House for its appropriate action. Part of the conduct that is prohibited under this Act includes improper influence of members of Parliament, fraud, intimidation, offer or promise of any inducement or benefit of any kind of a member in the performance of the member's functions. It is prohibited for members to solicit, receive, or accept any fee, compensation, gift, reward, favor, or benefit of any kind for undertaking or for going to undertake their functions. Honorable senators, for the Senate to invoke this framework, it is most helpful that the information available to the executive and other organs and agencies or other persons is shared with the Senate. As the Speaker of the Senate, I have not received any complaint or information relating to bribery or extortion or any other corrupt practice against a senator from a member of the executive, ministries, department, or agencies of government, a governor, or other county government agencies. If I do receive such complaint, I am obligated and I will take the necessary stern action without delay. Now, honorable senators, concerns have also been expressed about the manner in which Senate has prosecuted its mandate relating to the impeachment hearings for the proposed removal of state officers. The conduct of the Senate in matters impeachment is a matter of public record. It does not show any consistent pattern of acquittal or confirmation of impeachment charges. Of the 19 impeachment proceedings that the Senate has undertaken since 2014, in 8 instances, the Senate has found the charges against the state officer to have been substantiated and has confirmed the impeachment. While in 9 instances, the Senate has found the charges not to be substantiated and has not confirmed the impeachment against the state officers. Notably, in 2 instances, the Senate has dismissed the proposed impeachment for failure to meet the threshold of the law. The Senate has conducted the impeachment proceedings in accordance with the Constitution and the laws and has made its determination on the basis of the evidence and the law. I repeat, the Senate has conducted the impeachment proceedings in accordance with the Constitution and the law and has made its determination on the basis of the evidence and the law. In respect, as in the matters, in this respect, as in the other matters, the Senate welcomes information of any evidence of inducement or other impropriety by any senator for appropriate action in this regard. Honorable senators, in the course of the last 1 week, statements have been made questioning the constitutional mandate of the Senate to oversight a particular category of state officers, namely county governors. It has been contended that the oversight role of the Senate should be limited to the national government and that oversight over county governors is a preserve of county assemblies. Article 96 of the Constitution sets out as part of the role of the Senate to represent the counties and to protect the interests of counties and their governments. Article 96, subarticle 3, is explicit that the Senate determines the allocation of the national revenue among counties as provided for in Article 217 of the Constitution and exercises oversight over national revenue allocated to county governments. I repeat that one. Article 96.3 is explicit that the Senate determines the allocation of the national revenue among counties as provided for in Article 217 of the Constitution and exercises oversight over national revenue allocated to the county governments. That is the Constitution. Furthermore, Article 125 of the Constitution decrees that either House of Parliament and any of its committees has power to summon any person to appear before it for the purpose of giving evidence or providing information. This is exactly what the Senate has been doing and will continue doing. Apart from the clear provision of the Constitution on the matter, the superior courts have made a number of decisions addressing the questions of jurisdiction of the Senate to summon and exercise oversight county governors and other county government officials, and the demarcation of the oversight function between the Senate and the county assemblies. In the High Court petition number 334 of 2016, Kialo Kamina versus Senate and others, the court held as follows on the question of oversight responsibility of the Senate. And I quote, "The Senate and the county governments are to work together to ensure that the purpose of devolution is achieved. The two bodies cannot work separately, and since the county government receives funds from the national level, they cannot check themselves. Accountability has to come from a body not within the county level, thus the Senate." These are the words of the courts. The Supreme Court, in petition number 24 of 2019, between the Senate and the Council of Governors and others, while also considering the issue of the mandate of the Senate, the court stated as follows, and I quote, "The purpose of the Constitution is to entrench good governance, the rule of law, accountability, transparency, and prudent management of public finances at both levels of government. Such grand purpose cannot be served if either the Senate or county assemblies begin to develop centers of oversight influence. In this regard, the county assemblies provide the first tier of oversight, while the Senate provides the second and final tier of oversight." This is a pronouncement by the court. In the end, the Supreme Court held that in the performance of its oversight role over county revenue, the Senate has powers to summon county governors to answer any question or provide and requisite information. On this matter of the oversight jurisdiction of the Senate, therefore, the Senate cannot yield or concede. Unless the Constitution is amended, the constitutional mandate of the Senate is non-negotiable or discretionary. It is a solemn trust it vested on the Senate, while the Senate will continue to discharge faithfully and without fear or favor. Now, honorable senators, let me conclude by making an impassioned plea to the executive, other agencies of government, county governments, and other persons that it is incumbent on all of us to protect the institution of the legislature, which is the cornerstone of democracy. Holding the legislature to account and requiring the highest standards of integrity is laudable, but it needs to be followed by collaborative action with the legislature itself, by favoring the appropriate officers of the legislative arm with information available to the executive and to other agencies so that the legislature can invoke mechanisms at its disposal to take swift and stern action against errant members. The executive, as well as other agencies and all persons, should also support the Senate in its oversight role in defense of the devolved system of government, which our people so painstakingly weaved together for themselves in order to address the disparities and inequalities and other injustices of previous centralized constitutional order. I thank you, honorable senators. Yes, honorable senators, I thought I was very elaborate in this communication. So let's leave it there, honorable senators. Let's leave it there. Yes, honorable senators.